There is an email sitting in the congressional record right now that the Department of Justice had in its possession and did not disclose. It was sent on March 7, 2010. The sender was Sarah Kellen, one of Jeffrey Epstein's personal assistants. The recipient was a coordinator at the Trump Organization. The subject line was Mar-a-Lago Event Coordination. According to the document as entered into the record by Congressman Dan Goldman, the email states that Epstein would attend a Saturday event that Trump approved, and that Epstein would bring 3 people from his list. Attached to that email, according to Goldman's account of the document, were 3 names with ages listed alongside them. The youngest was 16 years old. This email was allegedly part of a transfer of 847 emails sent from the FBI to the Florida Attorney General's office between 2015 and 2016. At that time, the Florida Attorney General was Pam Bondi. Record logs, according to Goldman, show the email was marked high priority. Record logs show her office received it. Record logs show it was accessed. Until this hearing, the public had never seen it. These specific claims have not been independently verified outside the hearing. What has been verified is that Goldman reviewed unredacted materials at the DOJ the day before the hearing, that he produced documents in that hearing room, and that Bondi's response to his questions was a single word, repeated: privilege. Dan Goldman is not a politician performing outrage for a camera. He spent nearly a decade as a federal prosecutor in the Southern District of New York, the office that handled organized crime, financial fraud, and some of the most complex federal cases in the country. He served as lead counsel during the first impeachment of Donald Trump. He knows what a privileged document looks like. He also knows what a privilege claim that does not hold up looks like. And when he held up an email between Jeffrey Epstein and Ghislaine Maxwell, 2 convicted criminals, neither of whom is an attorney, neither of whom had a legal relationship that could generate privilege, and Bondi responded with privileged, Goldman told her what any first-year law student could confirm. Attorney-client privilege does not apply to emails between co-conspirators. It does not apply to communications that furthered criminal activity. The crime-fraud exception exists for precisely this situation. Bondi is a lawyer. She knows this. The word privileged in that moment was not a legal position. It was a door being held shut. Now stay with me, because what Goldman found in those files goes beyond any single email. He reviewed the unredacted materials at the DOJ and found that nearly half the documents required by federal law to be released are still being withheld. Among them, an 86-page prosecution memo from the Southern District of New York. A draft indictment from Florida against Epstein's co-conspirators. These are not peripheral administrative records. A prosecution memo is the document where federal attorneys lay out the evidence they gathered, the witnesses they interviewed, the names they believed were criminally liable, and the reasoning behind every decision they made about who to charge. A draft indictment contains the names of individuals prosecutors believed had committed crimes. These documents exist. Goldman found them. They remain redacted, not just from the public, but from members of Congress with the legal authority to review them. According to unverified accounts from sources familiar with the committee's ongoing document review, the prosecution memo contains references to at least 3 individuals currently serving in senior executive branch positions. These accounts have not been confirmed. What is confirmed is that Bondi could not provide a legally coherent explanation for why a prosecution memo is being withheld from congressional oversight. She invoked privilege. When Goldman pressed her on the specific legal basis, she suggested he was not a good enough lawyer to understand. A former SDNY organized crime prosecutor. Not a good enough lawyer. The redaction pattern Goldman identified is identical to what Massey exposed in a previous hearing, and it bears repeating because the repetition is itself the evidence. A document titled Epstein Victim List, 32 names, 31 of them fully visible to anyone who downloads the DOJ production, 1 redacted. This is not a volume problem. 3 million documents and 1 specific name on 1 specific list needed a black marker. The department touched that document. They made choices inside it. They redacted the one name that was not a victim and left 31 victims fully exposed. The same victims whose lawyers had written to the DOJ explicitly asking that their names not be released. The DOJ published that letter too, the one asking them not to expose the survivors. They published it with the survivor names intact and the lawyer's name redacted. Someone in that building is making these decisions. That person has a title and an office and a chain of command that ends at the witness table. There is a second set of documents that has circulated among investigators following this case, and which demands careful examination precisely because it has not been confirmed through official channels. According to unverified accounts, forensic analysts examining materials recovered from offshore servers identified an email dated March 17, 2019, 6 months before Epstein's arrest, sent from Epstein to Maxwell. In this alleged email, Epstein describes a coordination meeting in Palm Beach and references assurances from what he describes as friends in the new administration that oversight would be redirected. The email allegedly references Kash Patel by name as someone briefed on the coordination strategy. 3 independent forensic firms are said to have reviewed the metadata and authenticated the document. None of this has been confirmed. Patel's representatives have issued denials, but the specific language attributed to this email, if authentic, would transform what is currently a perjury investigation into something considerably more serious. We will continue to follow the verification process on this document as it moves through official channels. Goldman then did something that cut through every procedural argument in the room. He asked the survivors who were present, sitting directly behind Bondi in the same room, to stand. He asked them how many had met with the Department of Justice to provide testimony. None raised their hand. He asked how many had reached out to the DOJ to offer evidence. Every hand went up. He asked how many had been denied or ignored. Every hand went up. Deputy Attorney General Todd Blanche had told the public the previous week that any victim who wanted to speak with the department had done so. Every person in that room with direct personal knowledge of Epstein's network had reached out. Everyone had been turned away. Bondi did not turn around. When Goldman noted that she apparently had more witnesses available if she wanted them, her time expired. What followed illustrated the specific tactic this department deploys when the questions become unanswerable. Bondi produced photographs, immigrants convicted of violent crimes, names, countries of origin, specific offenses. She began reading them aloud: assault, arson, rape. When a member attempted to note that 70% of detained immigrants have no criminal conviction, Bondi continued reading. This is not a response to a question about why an 86-page prosecution memo is being withheld from Congress. It is a replacement for one. The photographs are real. The crimes in them are real. They have no legal relevance to the question of why a victim list with 32 names has 31 of them visible and 1 hidden. Their only function is to fill time and change the subject while the clock runs down. Here is the legal reality in plain terms. Perjury requires a false statement made under oath about a material fact. When Bondi testified that there was no evidence of criminal activity by Trump in the Epstein files, she made a statement that influenced whether Congress would confirm her as Attorney General. If the 2010 Mar-a-Lago email is authentic, and she had access to it through the 847 email FBI transfer to her office during her time as Florida AG, her testimony may constitute a material false statement. That determination will be made through formal proceedings. What is already in the congressional record is the email, Goldman's account of the record logs, and Bondi's response when asked to commit to releasing the unredacted version. She said, "Privilege." The committee voted to continue. Liu and Goldman have formally requested that Todd Blanche appoint a special counsel to investigate Bondi for perjury. The committee has not yet voted to release the emails publicly. Those are the next procedural steps to watch. Not because congressional hearings always produce accountability, they often don't, but because the documents Goldman entered into the record do not expire at the end of a session. They sit in the permanent record of the United States Congress. And the people who said privilege instead of answering are counting on the news cycle to move faster than the oversight process. It has not moved fast enough yet. Stay with us.